Hello, everyone. I'm
So
Prateek Sibul.
I have not watched the whole video. I am reacting as I'm watching it with y'all. So I want to thank everybody that's here with a shorty today. I want to thank everybody that's rocking out with a shorty because y'all don't gotta be here, but y'all rocking with a shorty today. Thank you. Today we're not building caskets for nobody. We're not digging a hole 7 feet underground to, bury a body that has, you know, that's become a predator and stuff like that. So today we're just going to talk about robots, AIs. Will they take over the world? Will they help out? What are y'all opinions? What do y'all think?
program specialist at UNESCO, and I lead the work around artificial intelligence and the rule of law here. Welcome to the UNESCO series on AI and the rule of law. This is the second webinar in our series where we are going to talk about the admissibility challenge when it comes to AI generated evidence in courts. We will be discussing issues related to AI generated evidence. In fact, can it even be considered evidence, or as Professor Sabine Gless has written in a paper, we're talking about machine testimony. Then we will deal with questions around bias, around discrimination, around reliability, explainability, trustworthiness, and then also discuss what can judges do. And here, Judge Paul Grimm has some pointers also in his paper, and we'll also be sharing all these articles with you later. Just a brief note on UNESCO's Judges Initiative. UNESCO has been engaging with judicial operators in these kind of dialogues since about 10 years now on questions related to freedom of expression, access to information, safety of journalists, and since about 2020 on AI and the rule of law. We are a community of about 25,000 judicial operators from over 150 countries around the world. And we are very glad to be engaging in this dialogue with you today on artificial intelligence. I would now invite our partner in this webinar, one of our partners. We are partnering with the National Judicial College in the
Copyright
United
disclaimer
States,
under
the
Section 107
Inter-American
of the
Court of
Copyright
Human Rights.
Act of 1976, allowance is made for fair use for the purposes such as criticism, comment, news reporting, teaching, scholarship, education, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Fair use allows limited use of copyrighted material without permission from the copyright holder for purposes such as criticism, parody, news reporting, research, and scholarships and teaching. Disclaimer: the views and opinions expressed on this video or any video, including the Writers for Life Brings You to Let's Talk About It podcast, do not reflect on the opinions of your shorty Racheal and the members of the Writer for Life podcast. Everything we talk about is allegedly and is our opinion. Our videos are not recommended for minors. Everything we talk about and do is meant for educational purposes and also entertainment. Please keep in mind that the majority of our videos are for educational purposes only. This world is crazy. I would say shady. Ironic, right? Nowadays, you can't trust no one. When you do, niggas be having their panties all in a bunch, thinking that they own one. Saying the things that you accomplished in life is theirs and that you owe them one.
Rights. We are partnering with Lawyers Hub in Kenya and the National Law University's Center for Communication Governance in Delhi. And we have Ms. Chalak Kakkar, who's the Executive Director of the Center for Communication Governance, here with us to share some opening words before we move ahead. Over to you, Chalak.
Thank you, Prateek. The Center for Communication Governance at National Law University is really excited to be partnering with UNESCO and our other partners on a series of webinars on important issues emerging around artificial intelligence, whether it's emerging issues of IP rights, generative AI, today's webinar on use of AI-generated evidence, as well as the use of AR and VR in courtroom. We are a research center based at the National Law University in Delhi, and our mandate is to ensure that the Indian legal education system engages more meaningfully with information law and technology. And towards that end, we undertake academic research, policy input domestically and internationally, as well as undertake capacity building of key stakeholders in the system, including judges and government officials. And that's where we've been working with UNESCO over the last couple of years, and have also, been involved in their initiative around training of judges under the AI and Rule of Law initiative, as well as other panels and events on issues around AI. And I think, it's a really, really crucial issue to be talking about, because the idea of, courts in a rule of law context is the delivery of justice. And there's increasing adoption of artificial intelligence within court systems, overburdened court systems, overwhelmed court systems, in a hope that this will help bring about efficiency and enhance the delivery of justice. But in all of this, we have to balance all the competing interests and ensure that the focus remains finally on justice delivery and ensuring, the realization of the rights of marginalized, vulnerable communities. And this doesn't come at the cost of, core principles that are dear to us in democracies around the world. So we're very excited to be partnering with UNESCO on this particular webinar on the use of AI-generated evidence. And as the scope and use and misuse of AI-generated evidence advances, it becomes really important for us to enhance the capacity of judges and judicial officers, as well as other stakeholders in the system, around how to engage with such AI systems and AI-generated evidence. Okay. So I want to thank UNESCO for bringing all partners together to organize this webinar, and I'm really excited to hear what our wonderful panel of speakers has to tell us today. I'll hand over to the moderator, Isabella Ferrari, to kick the session off.
Thank you very much. It's a pleasure to be here. My name is Isabella Ferrari.
Yo, I've noticed that everybody is so hype about these AIs. Like, if we ain't watch all these movies, and I don't know, you know what? I'm gonna end up doing the live of the Let me see if I find it. And I'm gonna let her talk and see if I can find the producer that did Terminator, and see if I can get her interview.
I'm a Brazilian federal judge, and now for our opening keynote, we're receiving Professor Sabine Glass. She's a professor of criminal law and criminal proceedings at the University of Basel, and she's also a visiting scholar at NUS Law and an expert in criminal law and criminal procedure with a research focus on law, AI, and robotics, and the admissibility of AI-generated evidence in criminal court. She's a professor of criminal law and criminal proceedings at the University of Basel. So, Professor Glass, we welcome you, and the floor is yours.
Thank you very much for this nice introduction. Good afternoon, everyone. And I would now ask to share my slides. And meanwhile, I'm happy to thank everyone who organized this panel for organizing it, and all of you participating to engage in another Zoom meeting. As my colleague said at the beginning, we are all very much looking forward when we can perhaps meet personally at some point. What is the admissibility challenge of AI-generated evidence? That's our question today, and I would ask you to go to the first slide, please. The example I will use, and I have used before because many people can relate to it, and also our panelist Stephen Mason is an expert on it, is modern driving, using cars equipped with driving assistance systems. Such assistance systems, like drowsiness detection systems are a great achievement for helping improve safety and convenience for drivers, but also for those around them. But their constant monitoring and assessing of the human performance can lead to that admissibility challenge of AI-generated evidence, because their non-stop observation makes them seemingly... Basically, to break it down, these AIs still malfunction, and they want us to take it into society and live with them. Ideal witnesses. Next slide, please. Imagine you drive in a new car to your office in the morning, well rested, looking forward to your day, but all of a sudden, the car beeps, the driving wheel vibrates, and the coffee cup sign recommends you to take a break. This alert is based on AI. It's based on the car's reading of your lane keeping, your sitting position, your eyelid movement. And so the alert is what we would call AI-generated evidence. Imagine that you simply ignore this warning because you feel well rested and alert. Yet, minutes later, you hit a motor scooter that you did not see coming. It is easy to imagine further that investigators who examine the accident find that you had been alerted to the possibility that you might be driving while drowsy. The prosecution would want to proffer the alerts recorded by the car as evidence that you had been warned that you are tired and that you actually were tired. Consequently, the prosecutor might level 2 accusations against you: driving while unfit to do so, and negligently causing bodily harm, as you should have taken a break or gotten off the road. Next slide, please. This is not science fiction. In Europe, a new regulation mandates all cars to be equipped with a driver drowsiness and detention warning system. And that is from 6th of July 2022 for new types of cars, and from 7th July 2024 for all new vehicles. Next slide, please. The admissibility challenge lies in the question, and that's the question that was referred to in the introduction, as that mandates a court with searching for the truth. Next slide, please. But both systems have a safety precaution for evidence that cannot be tested through confrontation. Usually cross-examination would be excluded.
Okay,
next slide,
so I never skipped. Never mind.
That was referred to in the introduction as, find that you had been alerted. The admissibility challenge lies in the question, and that's a question that was referred to in the introduction as, providing justice, whether judges as gatekeepers for sufficiently reliable evidence in courtrooms should allow drowsiness detection alerts as evidence in a criminal trial or not. The starting point in all jurisdictions I know is the following. As a rule, all relevant evidence is admissible. If there are concerns regarding the reliability, it goes against the weight of the evidence, not the admissibility. It is left for the trier of facts, jury or bench, to decide whether evidence is persuasive. As an exception, however, inherently untrustworthy evidence can be excluded. For instance, a witness testimony proffered as evidence that cannot be tested through confrontation, usually cross-examination, would be excluded. Next slide, please. It would now be interesting to put into detail this rule and exception model in all the jurisdictions represented in our webinar. I can only point to 2 domestic statutory regimes that are on the panel, and that's the US Federal Rules of Evidence and the Swiss Criminal Procedure. And if you very quickly read through them, you see that Rule 402 of the US Federal Rules of Evidence just allow for the general admissibility of all relevant evidence, as does Article 139 of the Swiss Criminal Procedure that mandates a court with searching for the truth. Next slide, please. But both systems have a safety precaution for reliable evidence, with the accused having the right to confront incriminating evidence. And in the US, that is case law and rules. Will not go further into that. Perhaps Judge Grimm will mention some more, but that's the Sixth Amendment, which gives a right to confront evidence to all defendants. And in Europe again, and that's now true for all of continental Europe and the UK too, Article 6, paragraph 3 gives everyone charged with a criminal offense the following minimum right.
I don't know if any of y'all noticed, but they are trying very hard to convince the world that this AI robot lawyer and AI robot judge could really benefit us citizens.
Rights, including the right to confront. Now, when these statutes have been written, there was more witness testimony on the minds of the lawmaker, but it has been expanded, and in Europe, prominently by the case law of the European Court of Human Rights in Strasbourg. Next slide, please. The question now arises, how could defendants meaningfully confront a drowsiness detection alert? Now, the traditional way would be that parties or the bench appoint an expert witness, and that the expert witness can explain the accessibility, the traceability, and the reproducibility.
Yo, do they really got a jury box over there full of jurors, right? And a car on the plaintiff side? Yeah, on the plaintiff side. I don't know if that's the plaintiff or the defendant side, but they still got the car. That's basically what, the robot? Like, yo, they tripping. They funny as shit with these little comics, though.
Usability of such evaluative data like drowsiness detection alerts. But the question is, would this enable defendants to meaningfully confront the incriminating data? And would it eventually enable the trier of facts to evaluate the reliability of such evidence? Our doubts result from the fact that experts in such a scenario face many hurdles. First of all, the so-called black box problem, the issue that internal algorithms or decision-making processes of a system are not fully transparent or explainable. And this concerns worsen as the black box problem may be entangled with a trade secret issue, that is confidential information that the car maker will not disclose because of their protection of a competitive advantage in car design.
Why they looking bored over there? They chose these slides, not yo.
And these problems are combined with more problems, and that result in what has been described as a mission creep problem or function creep by our panelist, Judge Grimm. I understand in an article that will be shared with you, very interesting article on the problem that sometimes functions of AI systems are expanded beyond its original intended purpose or scope, like using drowsiness detection alerts as evidence in a criminal court, while the driving assistants generating such alerts have only been designed to warn the driver of their performance during driving automation. And this is different from intended forensic tools like breathalyzers or DNA sample tests. Car and driving assistance systems are not designed as forensic tools. They lack a proper metric or certification or any other system that would really document their trustworthiness. Next slide, please. The challenge judges face when deciding on the admissibility of AI-generated evidence is to not block relevant evidence from their courtrooms because justice must be provided, but also to not allow possibly biased evidence that cannot be confronted. And this is particularly difficult with AI-generated evidence that is a result of mission or function creeps, and I'm sure Judge Grimm will speak to that. As we have seen with the example of drowsiness alerts, the evidence provided is a subjective observation of a system like a witness observation, not a measuring operation. For instance, drowsiness detection systems are designed, trained, and calibrated by car makers to ensure that human drivers are ready to take over the steering wheel if necessary. It is very likely that the car producers aim to alert the driver more often than necessary so that they are on the safe side.
See, a person can control a vehicle, but a person cannot control an AI judge or an AI lawyer. Like, all them things is looking for is money, and they already programmed. Like, they really trying hard to convince us that the AI, man.
If such a drowsiness alert is then presented in court, the question, how can a defendant meaningfully confront it? And today we know still very little about how drowsiness detection works in a certain car, but it seems possible that they have what is known as the white guy problem. Such a problem arises when data is used to train such system that is not diverse enough. For instance, the training data used to teach drowsiness detection systems will lack diversity when it's predominantly young white males who volunteer to engage in a computer game used to gather the testing data.
Wow.
And then consequently, the drowsiness detection system may not be accurate when assessing other groups or individuals like elderly females with drooping eyelids or drivers with dark skin.
Wow.
And so I would say overall a mission creep, a function creep's observation is likely to.
So basically all dark-skinned drivers are the ones with the problem. This sounds kind of like a little racist to me, but let's continue to listen.
Be biased. Next slide, please. Now, the question we will discuss today is, are there new feasible ways to check reliability of AI-generated evidence? I think there are. I can't explain them in detail here, but please allow me to refer to two works we did. The one is called Carwert Mtor, Crowdsourcing Data to Challenge the Testimony of In-Car Technology, Beware of Your Car. And there we address the situation in which a car acts as a witness against its human driver in a court of law. And we suggest that crowdsourcing data could be a viable option for assessing the trustworthiness of such evidence. And we encourage lawyers, judges, and lawmakers to remain open to such a strategy. In the other article that is for now only published in German, Intelligente Agenten als Zeugen im Strafverfahren, but will come up in a book with Cambridge University Press next year, we propose to go new ways and, for instance, really search for an AI-driven tool that is able to vet AI systems. Next slide, please. Now, it's clear that our propositions raise new questions. And again, I cannot explain them in detail, but it's clear that privacy issue will play a huge role in solving the problem that we have at hand. With that, we come to my last slide. To conclude, I take that AI can, in principle, generate valuable evidence for fact-finding in criminal cases, and that it's important if you want to provide justice. But as it stands now, procedural laws lack the tools for the fair use of it. In particular, we lack rules for presentation in a form that allows the vetting of reliability and the validity for fact-finding. In particular, the confrontation of such evidence in a meaningful way. Therefore, I think domestic lawmakers, and we will hear whether they do that in some countries, must come up with a new proper legislation, and the actors in the criminal justice system must be trained to use or to discard AI-generated evidence. And legislators will have to solve the problem of privacy protection. Thank you very much.
Thank you so much, Professor Glass.
Basically, there's going to be a lot of invasion of privacy. Like, listen, man, let me come up for this. We already know they already got people putting the chips in their hand and much more. They got the AI dogs and police force in a lot of places. They got in a lot of restaurants. They got already is a lot of AIs in there serving and behind a register. So the biggest question is, will all AIs take over a lot of people's jobs, including lawyers and judges? But my biggest question is it good? Is it a good idea to have AI judges and AI lawyers? That's my biggest questions for y'all. Like, I would love to hear y'all comments once again.
For organizing perfectly the topic and for sharing with us your thoughts. And now we're starting the panel. And the first question goes to Judge Paul Grimm. Judge Grimm is a professor at Duke Law and a former Maryland district judge. So Professor Grimm, how does the increasing use of digital, electronic, and AI-generated evidence in court impact traditional rules of evidence and the legal framework surrounding admissibility? Can you please provide us some cases of where admissibility of electronic or AI evidence was questioned?
Yes, thank you very much. It's an honor to be here. I'd like to sort of pick up where Professor Glass's excellent introduction framed the issues for us. When we're talking about artificial intelligence evidence in any of its forms, including ChatGPT or generative AI, we're talking about non-testimonial evidence from humans. We're talking about information that has been the product of computers. Therefore, the rules that govern its admissibility, as Professor Glass said, are relevance, and the evidence rules of every country that I'm aware of have a presumption that relevant evidence will be admissible. And relevant evidence is evidence that has a tendency to prove or disprove something that has to be decided in the case. Now, the decision as to whether evidence is relevant is made by the judge, and the judge, as Professor Glass said, must be a gatekeeper. Here, you have to keep in mind that most evidence rules, whether they're drafted by statute or in the United States by a committee that proposes rules that ultimately are approved by Congress, the rules tend to be technology neutral, because changing rules takes time, and technology doesn't wait for anyone. So
and basically, these AI judges and AI lawyers will be speaking basically by what they're programmed to say. So imagine somebody really being innocent and found guilty because of a mistake by an AI. Nobody's really seeing that. Everybody's so, oh my God, technology, the Jeffersons, the Jetsons, my bad, I said Jeffersons, the Jetsons and shit. Like, like, y'all ain't watch all them Will Smith movies.
Technology marches forward and is immediately used. The different legal systems adjust to this differently. In the United States, the presumption is, and the basic assumption in the rules of evidence is that members of the community, jurors, will decide civil and criminal cases and decide the facts, and the judge just rules on the legal issues. In many other countries in the world, they don't have the jury system as pervasively for all civil and criminal cases. So this role of determining whether the evidence is going to be considered in determining the outcome of the case falls to the trial judge. As Professor Gless correctly said, there is a tension in the evidence rules where relevant evidence is presumptively admissible, but evidence that is not reliable and can be demonstrated to be unreliable to such an extent that allowing it to be considered in the case would produce a risk of an unjust or unfair outcome can be excluded by the judge, whether the judge is the one deciding guilt or innocence or whether it's a jury. And the way in which the judge approaches this, as Professor Glass said, in all countries, is to look at issues of reliability, sometimes it's referred to as explainability or trustworthiness. And it really are two components that kind of merge under the notion of reliability. One is validity. Does this artificial intelligence software application do what it claims to be able to do? And the second is it reliable? Does it consistently produce accurate results?
I wouldn't put my life on a robot if, let's say, even if the God himself asked me, which I doubt. Like, yo.
When it is applied to similar factual circumstances. And the only way in which these questions can be answered is if during the pre-trial phase of the case, the parties have access to sufficient information to be able to demonstrate to the judge the method by which the artificial intelligence application was designed, tested, the purpose for which it was intended to accomplish, and whether or not it is being used in the particular case for the purpose for which it was tested, and if it is reliable.
Let's rewind it back a little bit so
as
y'all can hear
Professor
that
Glass
again.
noted, relevant evidence is presumptively admissible, but evidence that is not reliable and can be demonstrated to be unreliable to such an extent that allowing it to be considered in the case would produce a risk of an unjust or unfair outcome can be excluded by the judge, whether the judge is the one deciding guilt or innocence or whether it's a jury. And the way in which the judge approaches this, as Professor Glass said, in all countries, is to look at issues of reliability, sometimes it's referred to as explainability or trustworthiness. And it really are two components that kind of merge under the notion of reliability. One is validity. Does this artificial intelligence software application do what it claims to be able to do? And the second is it reliable? Does it consistently produce accurate results when it is applied to similar factual circumstances? And the only way in which these questions can be answered is if during the pre-trial phase of the case, the parties have access to sufficient information to be able to demonstrate to the judge the method by which the artificial intelligence application was designed, tested, the purpose for which it was intended to accomplish, and whether or not it is being used in the particular case for the purpose for which it was tested, and if it is reliable and valid. As Professor Glass noted, this implicates issues of trade secrets. The developer of the artificial intelligence software does not want it disclosed. Some judges faced with this problems have protected the trade secret nature as confidential and not allowed it to be disclosed. Other judges, in my personal view, did it the right way. They issued a protective order to enable disclosure to the litigants under circumstances that will not threaten the competitive advantage for the developer of the software. The way in which you have to analyze this is the way in which experts analyze any kind of scientific, technical, or specialized information. Number one, is the person who is explaining how it works qualified to do so? Have they based their testimony on sufficient factual information?
Mm-hmm.
Are the methods and principles used reliable? Have they been reliably applied to the facts of this case? And this means that issues such as, has the methodology been tested? By whom? Have the test results been made public? Is the data unbiased on which it was tested?
Facts.
Is it being used for the purpose for which it was designed to be used, which gets into the issue of mission creep? It is these types of questions that the trial judge needs to have information developed during the pretrial phase to allow the parties to argue whether or not these reliability criteria have been met, so that the judge can make that fundamental determination of relevance. Evidence that is technical, that is not valid and reliable, does not tend to prove things. If it doesn't work, it doesn't prove things, and therefore it is not relevant. So this is kind of complicated, but it hinges upon the judge's management of the pretrial phase of the case to make sure that the information is necessary for the parties to argue about whether these fundamental evidentiary concepts have been met, and the judge to determine whether or not it is admissible. If it is admissible, then the weight is to be decided by the fact finder. You asked for me examples of when it's been used. I can tell you right now that in civil litigation in the United States involving an automobile, Professor Gless, as you indicated, this was a self-driving automobile. In 2007,
That's an automobile. Now, an automobile doesn't determine if somebody spends years in jail or they go free, or if they get a life sentence, or if they get, the death penalty.
Elon Musk was interviewed online, and it was posted on a website, and he was saying that artificial intelligence applications in the manufactured cars by his company are safer than human drivers and are perfectly safe. In an accident involving a pedestrian, the lawsuit attempted to introduce those comments from Elon Musk into the civil litigation. Musk's attorneys objected and said, there are so many examples of him in the public sphere talking that through deepfake technology, you can take that language, put it into a computer, type the text that you want it to say in the computer, and it will replicate in his language, the language you want. And judge, we want you to exclude it. The judge said, no, you are saying something is a possibility, but you have not demonstrated in this case that this is what happened, and therefore they have excluded it. And I think that perhaps Professor Mason may be able to provide an example of this, but I'm aware of one case in the UK. It was a domestic case in which the wife introduced what was purported to be a video recording of the husband saying something that indicated that he was an unfit parent. The court issued an order based upon that, and upon appellate challenge of that order, the father was able to demonstrate it was a deep fake, and therefore the evidence was excluded and the result was changed from the court. The challenge that we all face, and then I'll turn it back over to our moderator, is that there is a dual threat here, because the ability to demonstrate that some evidence that appears to be authentic is actually fake creates the issue that the outcome of the litigation may be unjust, because unauthentic evidence is accepted as authentic. But on the other side, the public awareness and the pervasive knowledge that this technology enables evidence to be faked allows a person who has evidence that is authentic offered against them, which is the result of computer systems, can now argue in a conclusory fashion, this is a deep fake, and you now run the risk of having the fact finder confused and believing that authentic evidence is not authentic. So it's a double threat. And this last example is what has been referred to by Professor Citron in the United States as the liar's advantage. So these are issues that judges are facing, and I'll turn the control back over to our moderator.
Thank you so much, Professor Green.
And I'm gonna pause it right there real quick. All right. And that man spoke facts right there. Let me